40 Act?
Yes, my lord. I'll come to that, my lord. There is only one judgment which talks of stamp duty. There's a
1940 Act.
1940 Act. 21 Calcutta. I'll come to that, my lord, in a moment. There is only one judgment. There is no real case of stamping or stamping. Lordship knows under the 1940 Act, there are various chapters. There is Chapter 2 arbitration without intervention of court.
That's right.
Then Chapter 3 arbitration. Chapter 2 is my lord. Then 3 with intervention of court. 4 arbitration in a suit. So, my lord, that regime is slightly different. I'll come to, my lord, that at the appropriate stage. My lord, so your lordships had a look at the Stamp Act, and my lord, today I wanted to place, my lord, the relevant provisions of the Arbitration and Conciliation Act. Yesterday, your lordships had a look at some of the sections. Section 2, subsection 3, your lordships had a look at 5, 7, 8, and 11. My lord, these are sections that your lordships have already seen yesterday. I'm not going to repeat, my lord, on those 4, 5 sections. 2, 3 is on arbitrability. Section, my lord, 5 is non-intervention, non-obstante clause. 7 is the arbitration agreement. 8 is stay of proceedings, my lord, now reference to arbitration in a suit. 11 is appointment of arbitrator, which your lordships have seen. 11.6a, 11.6b, 11.13, my lord, which says you have to dispose of it within a very short time. So those provisions your lordships have seen. So, my lord, I pick it up from section 16, which according to me, my lord, is critical in deciding the reference, because, my lord, 11 cannot be seen in isolation. It has to be read along with 5 and in particular, my lord, 16. And I would respectfully submit, my lord, now after the 2015 amendment, 16 is to be given its full play. 16 must be given full play, my lord. It was curtailed in SBP. That SBP judgment has been legislatively overruled. 16 has to be given full play. Your lordships will first see 16, then, my lord, the model law on 16, just by way of contrast, and then 2 paragraphs of Justice Thakkar on section 16.
Yeah.
And that is the thread which has been picked up, my lord, in the NN Global matter in the 3 judgment. Let's get out that 21.
Yeah.
Get that. Hold on, may I just read section 16, because it is very, very critical to the argument of the scope, of the narrow scope of section 11 now. 16 says competence of arbitral tribunal to rule on its jurisdiction. The arbitral tribunal may rule on its own jurisdiction, including ruling on any objection with respect to the existence or validity of the arbitration agreement. So existence is covered, validity is covered, and it is an inclusive thing. So other aspects are also covered of jurisdiction, which may not be necessarily only existence or validity. So the word is including. And for that purpose, an arbitration agreement which forms part of a contract shall be treated as an agreement independent of other terms. No, this is the principle of separability and competence. And B, a decision by the arbitral tribunal that contract is null and void shall not entail ipso jure the invalidity of arbitration clause. Well, the 16.
Banerjee, is it a coordinate jurisdiction really? Because section 16 starts with arbitral tribunal may. Does it exclude 11.6?
My lord, it does not exclude 11.6, but there is the overlap, my lord.
What is your argument? That as a matter of prudence and practice, 11.6 court should avoid looking at this particular point.
There is some overlap between 11.6 and 16. The overlap is only qua the word existence. That's the first point, my lord. 11.6a only talks of existence. 16 also talks of existence. There, my lord, there is a judgment of your lordships in Praveen Electricals, which I will come to, Justice Nariman's judgment, which says that even qua existence, the 11.6a court will only make a prima facie determination and refer the matter even of existence to the arbitral tribunal. So, my lord, the overlap is very minor, and even where there is an overlap, it is as per the jurisprudence of this court, my lord, even existence prima facie is to be,
So 11.6a is examination of her existence.
that's all.
So what kind of an examination you are expecting?